The last panel is going to pick up a assorted bag full of Patriot Act issues and also talk some about the general framework of the civil liberties national security debate that has been going on in this country since September 11th, and that is often prompted when somebody mentions the word Patriot Act, which has become something of a lightning rod for everything that people concerned in civil liberties have become more concerned about post 9/11, and certainly the Patriot Act did work a number of changes in our federal laws. Not everything that's been going on that is of concern to civil libertarians can be traced back to the Patriot Act. Some concerns have arisen out of things the Attorney General has done by administrative order or the President has done by executive order. But that said, the Patriot Act is a very significant piece of legislation uniting and strengthening America by providing appropriate tools required to intercept and obstruct terrorism. Some staffer got a couple of weeks extra pay after coming up with that acronym because as things go in Congress today, you know, rule number one of introducing a bill is to give it a name that everybody says nobody can vote against that. And Tim will be talking about another such act a little later, the SAFE Act, which is the current vehicle for some efforts to revise the Patriot Act. I think it's safe to say no one in America has read the Patriot Act. Cover to cover, all 342 pages? Well, you're a magnificent person with magnificent endurance. It is impenetrable because, of course, as the Act is written, it is largely a series of interlineated changes in existing federal law, and you literally can't tell a thing about what it does until you hold it up against the U.S. Code or wait until somebody provides you with a red line version after it's passed. It amends over 15 major statutes, innumerable provisions of the U.S. Code. It deals with a wide range of topics, including information sharing between the criminal and intelligence sides of surveillance. It makes some changes in what is authorized under normal criminal surveillance techniques. It clarifies some points of law about when warrants are necessary to go after voicemail or computer information that was unclear prior to the legislation. It works a substantial number of changes in the authorities available under the Foreign Intelligence Surveillance Act, or FISA, and those have received a great deal of attention. It expands definitions of some federal crimes and some important categories like terrorism and terrorist activity. It expands the scope of what it means to provide material support to foreign terrorist organizations or to terrorism. It works major changes in the laws that enable the federal government to follow the money laundering, financial reporting, obligations and requirements of financial institutions. It makes changes in the immigration laws and the laws with respect to deportation. It increases Border Patrol funding, and it addresses some issues of computer security and cybercrime. And that's not all. I mean, there are other aspects of it, but those are some of the major divisions. I think in terms of the civil liberties debate, which I suspect will be a leading point of theme of focus this afternoon, I think you'd have to say the criminal surveillance changes, the FISA surveillance changes, and the changes in material support, the definition of material support, have attracted the bulk of attention and concern. As some of you know, that prosecuting people suspected of terrorist activities for providing material support has become one of the most favored prosecutorial techniques of U.S. attorneys' offices around the country, and it's because of the First Amendment and freedom of association issues that arise when that statute is being used that the civil liberty community is particularly concerned about the way that it's been applied. It also contains a provision that sunsets a number of the substantive provisions in the statute, and that sunset date is December 31, 2005. There will be a debate. One doesn't know of what duration and degree of sophistication, but there will be a debate in both the House and the Senate sometime this year about those provisions. Several attempts were made after Patriot was passed to get rid of the sunset provision through less open democratic deliberative techniques, but they did not succeed, and so the sunset provision has to be dealt with in one way or another during this term of Congress. One theme we've been talking about during this gathering is the fuzzy boundary between the war paradigm and the peace and law enforcement paradigm as it applies to things like rights of the government to detain individuals or to invoke military commissions versus normal criminal processes. I think Patriot Act suggests that there's another dueling pair of paradigms that also has a fuzzy boundary, and that's the distinction between a law enforcement structure that is aimed primarily at investigation and prosecution of crimes and a law enforcement structure that's aimed more importantly at prevention. And as you can tell from the Patriot Act, with its emphasis on obstructing and intercepting terrorism, the Patriot Act is a definite step in the direction of a surveillance state that is aimed more at preventing activity than necessarily prosecuting those who may or may not be eventual perpetrators of it. And that raises some substantial questions about whether we are drawing the balance between civil liberties and national security in an appropriate place in our interests to make sure that another 9/11 does not occur. So we have a distinguished group of panelists to talk about some aspects of this problem, which is broad and many-faceted, and we can't hope to cover them all today. I'll introduce them all briefly to you now and then invite them to speak either from where they're sitting or at the podium. Mary DeRosa is a senior fellow of the Center for Strategic and International Studies, has extensive experience both in and outside of government and working on national security issues, is, among other things, active with the Markle Foundation Task Force on National Security that Congresswoman Harman spoke highly of this morning. Well, we're not sitting in the order that we'll be talking. I'll introduce you in the order we'll be talking. That will confuse everybody. Bill Banks is at the end. Bill is a professor at Syracuse University and literally, I was going to say literally wrote the book on national security law, but the two of his co-authors are in the room, and so I have to say literally helped write the book on national security law, and is a longtime analyst and student of national security issues. Robert Chesney from Wake Forest, up the road, I-85, about 45 miles from us, has also been writing extensively and extremely perceptively about some of the post-9/11 issues, especially the use of the material support statute. And Tim Edgar is legislative counsel for the American Civil Liberties Union. And as the Congresswoman mentioned this morning, the ACLU is one of the organizations that is attempting to play a significant role in the upcoming debate over the sunset provisions, and in particular, working with people to build a coalition behind support of the SAFE Act. So without further ado, let me turn it over to Mary, and we'll get started.
Well, I thought I would use this time to talk about some of my frustrations with the Patriot Act discussion and debate. I'll use this sort of as therapy for this panel. I'm sure will be the exception, but I know will be the exception, but the debate in Congress, in the press, on TV, and even in some of the more academic treatments, I think has been full of misstatements, exaggeration, a lot of fear-mongering, and it's very difficult. I guess I know that I'm hopelessly moderate, but I don't see this as the Patriot Act as an all-or-nothing issue, and it is often treated as one, certainly by the government, although maybe that's changing a little, but also to some degree by civil liberties and privacy advocates. So first I thought I'd go through some of the arguments that I think are particularly annoying at times in the debate, and then I'd like to discuss one issue that I wish we were talking about more. I think a lot of people think we're talking about when we're talking about the Patriot Act, and that is information sharing, and with increased information sharing, how should we be protecting, what new things should we be doing to protect the privacy of U.S. citizens? But first, to talk about some of the common arguments, I think the most common that you hear from both pro-Patriot Act and anti-Patriot Act people is the disaster scenario. And this argument spins the most extreme tale of need for a provision or of a potential abuse of a provision, and concludes from that tale that if you don't leave the provision unchanged or eliminate it entirely, that these horrible things will happen. One example, I think, is in the that you hear a lot is with the sneak and peek provision of Section 213. Usually, or often, an argument is made about that provision that you will have a terrorist sitting in their home, and they have plans for the next attack, and they have information about people in sleeper cells, and if you give them notice that you've searched their home, then all of the cell will break up and the plans will be changed and national security will be harmed. Well, should you have a sneak and peek, be able to get a sneak and peek warrant under these circumstances? Of course you should. But is this an argument for the quite low judicial review provisions that the judge needs to find a reasonable cause to believe that there will be an adverse result from a warrant? I don't think so. In this case, if you had a standard of virtual certainty of adverse result, you would be able to get your sneak and peek warrant. So it is really not an argument about what the argument should be about, which is can we have the benefits of this provision with more searching judicial review? Maybe there is such an argument, but I'm not hearing it. And then the anti-Patriot Act people, to be fair, are masters of this particular device as well. You often hear that information sharing provisions will result in vast intelligence databases, and all of CIA personnel will have dossiers on innocent Americans. And I think it's safe to say that that is not an automatic result of the Patriot Act information sharing provisions. And it's true that the Patriot Act doesn't prohibit these things, but it sort of assumes, this argument sort of assumes that there is no authority out there other than the Patriot Act, and there are no other protections. Another argument, and this time a pro-Patriot Act one, and that is in response to concerns about abuses. You also often hear the response, well, the government won't do that. We don't have time to tap the phones of innocent Americans. We're too busy. That's just not the way it works. And it's sort of a trust us argument. And I'm actually a very trusting person. And I think in the overwhelming majority of the cases, it's true that people are not going to want to abuse the rights of Americans or willy-nilly run around and tap people that they don't need to tap. But I think where this argument falls down is that you need to remember that these are people who are fighting terrorism. And there is almost no more powerful motive to go to the edges of your authority. And we've seen, I think, in many cases, that people with good motives feel it is their duty to say, we need to lean forward, we need to do all that we can, and we're not doing our job unless we use all of the authority we have. So if you take the position that we don't need to build in limits because they're just not going to do that, I think it's an argument that's asking for trouble. Another one, the criticism that you hear from anti-Patriot Act people that a particular provision or an effort is unnecessary because it wouldn't have prevented 9/11. It has nothing to do with the problems of 9/11. You hear, for example, with the lone wolf provision, which is actually not a Patriot Act provision, but it sunsets with the Patriot Act provisions, that it wasn't necessary because it wouldn't have, because it wasn't necessary to get a FISA warrant on Moussaoui to have this lone wolf provision. That was just a misreading of the law. And I'm not actually commenting on that point, but the argument that it's not necessary because it wouldn't have prevented a specific thing that happened before. You hear it also with the Section 203 and the other information sharing provisions that these aren't necessary, we don't need these because it wouldn't have solved the problem with the Phoenix memo getting to the headquarters of FBI or the CIA getting the information about the two watch-listed individuals in the country to others who needed them. And I don't probably have to spend too long on this argument, but obviously the 9/11 scenario is not the only possible terrorism scenario, and shame on us if we're only thinking about that one and we're not trying to get ourselves authorities that address other scenarios. On the other hand, to continue with my moderate treatment of this subject, on the other hand, I think there's an enormous amount of overreaching on part of the pro-Patriot Act people, and it is not enough to say, as you so often hear, 9/11 changed everything, and you have a pre-9/11 mindset as a support for giving the intelligence and the law enforcement community basically any tool of authority that they think might be cool or useful, and you need to have a more better arguments than that or a more searching debate. So the one issue that I wish we were talking about, that you hear it touched on, but nobody, as far as I can tell, very few people other than to some degree the Markle Foundation Task Force that I've been working with has really been taking on, is assuming that there is greater information sharing, and to some degree the Patriot Act addresses that or makes that possible. But assuming that, what do you do what new things must we do to protect the privacy of Americans? First, I should say the Patriot Act information sharing provisions, in my view, are really pretty minor. They do one thing, and that is that now, or in terms of how they will affect information sharing, they do one thing, not completely insignificant, but certainly not sufficient, and that is that now it is harder for people in the law enforcement community, the Department of Justice, to say, I can't share this with you, I'm sorry, it's illegal. They can't really do that anymore now, the Patriot Act, whether it was true before, which I think it, for the most part, wasn't. It is, although in some cases there were issues, but I think it's now pretty clear that they are not prohibited from sharing intelligence information. But the much more complicated problems are, what do we do about the fact that maybe the backbone, or certainly one of the most important parts of privacy protection since the Church Commission in the 1970s has been what has been called the line at the border, but that's sort of confusing, but the line between foreign and domestic intelligence, the separation of responsibility for U.S. person intelligence and foreign, and that the foreign intelligence agencies in the United States, for the most part, have, since the Church Commission, have not been responsible for collecting information on U.S. persons or in the United States, and there are exceptions, obviously, but they, for the most part, haven't even had access to that information. But the intelligence threat, as we all know and we've all heard, is one that merges foreign and domestic, merges the foreign and domestic threat in a way that we never faced before, and we're seeing a recognition of this in things such as the role of the new DNI, the role of the National Counterterrorism Center, both of which have both a foreign and domestic intelligence function. But nobody is really dealing with what this means, and how do you, if foreign and domestic intelligence are being merged, How do you make sure that a U.S. person's information is being protected, because the old protection was keeping it away from a whole lot of people. I'm simplifying, obviously, but the privacy advocates often say the answer is we need to keep the lines. We need to keep the U.S. person restrictions. We need to keep the foreign and domestic split. The government, as far as I can tell, is kind of saying, oh, yeah, we're doing that. We have protocols, we're not mixing. But I think the right answer is either they are or they're going to be. It's inevitable almost with the new threat we're facing and with these institutions that we have created. And we need to face that and face how we can find new ways to protect privacy rather than just keeping it away. And I don't mean to say we need to completely eliminate. My personal view is I think that there is no need to have foreign intelligence agencies collecting intelligence on U.S. persons or domestically. I think in that respect the lines can remain, but for sharing information, for access to information, I just don't think it's possible. And I think the failure to address this really difficult issue is causing to some degree some paralysis in the government. Nobody knows what to do. Everybody, you talk to 10 different lawyers, you'll get 10 different lawyers in the government, you'll get 10 different answers to what can and can't be done with U.S. person information. And I'll just briefly say the Markle Task Force has talked about these issues and has said that you need to do things like have clear guidelines for access, use, dissemination, and retention of U.S. person information, require for access to U.S. person information a predicate, different predicates in different situations, but all having to do with some need related to terrorism, a preference for anonymized sharing that doesn't have identities in it, use of audits and oversight of the use of sharing, the information sharing environment, and the use of technology, including audit, authentication, permissioning technology, and other type of privacy protecting technology. But as influential as the Markle Task Force recommendations have been, I haven't seen this part of them, which is just critical, being picked up as much. And I think, again, that what's happening is it's just too difficult. But I just don't think it's something that can be ignored. Thank you.
Thanks to Scott and to Chris and to Judge Everett for putting on yet another very fine conference. I do have to say that I phoned home last night, however, and my cat, Rita, objects vociferously to denigrating her favorite cat food. I have to register that point. Many of you have heard about a wall that was supposedly taken down by the USA Patriot Act, and that's really what I'd like to talk with you about for a few minutes here this afternoon. What is a wall and what does it have to do with a panel on the Patriot Act? In a nutshell, one section, Section 218 of the Patriot Act, amended the FISA, the Foreign Intelligence Surveillance Act, and was interpreted by the Department of Justice and by a FISA court of review to eliminate essentially what has been referred to as a wall between intelligence collection and law enforcement. 218 was enacted subject to the sunset that we're talking about here, so an immediate question for today might be, what are the implications of extending or not extending the authority in 218? Second, the Patriot Act includes another information sharing prescription, one that Mary made reference to, although not by number. It's 504. That one was not made subject to the sunset, so if 218 lapses and 504 is left alone, what are the parameters of Justice Department discretion to use FISA for law enforcement purposes? One byproduct of 9/11 has been widespread and ongoing criticism of failures to interdict terrorists before they strike and to capture them while they prepare their schemes. Sometimes these critiques assert that the agencies responsible for knowing about potential terrorists, FBI, CIA, immigration agencies and such, failed to connect the dots. We've all heard that phrase now. Connect the dots of intelligence because they were not talking to one another or they were doing so incompletely or inefficiently. Examples include the CIA failure to share information about 2 known terrorists with FBI or INS until late in August of 2001, when efforts to locate them failed and the 2 boarded American Airlines Flight 77 and flew it into the Pentagon. Another is the well-known FBI Phoenix field office memo on al-Qaeda operatives interested in flight training at U.S. flight schools. Headquarters took no action, in part because CIA had failed to share its intelligence that terrorists might use airplanes as weapons. Former Attorney General Ashcroft spearheaded legislative reform efforts that culminated in the Patriot Act in the days immediately after 9/11, when he claimed that investigators had been shackled for years with rules that inhibited the sharing of information between law enforcement and intelligence officials. Now, a little background, and we'll get back to Section 218 and what's going on there. For decades, presidents claimed inherent power to conduct warrantless electronic surveillance in order to gather foreign intelligence in the interests of national security. However, in 1972, the Supreme Court, in a decision known by the name of the district court judge that first heard it, Damon Keith, in the Keith decision, the court held that the assertion of the president's national security powers will not excuse failure to comply with the Fourth Amendment warrant requirements during an investigation of domestic terrorists. The court expressly declined to express any view regarding investigations of foreign powers or their agents, although the court did opine in that opinion that traditional law enforcement standards may not have to be provided in such cases. Following the court's opinion and what was included in it, an oblique invitation for further attention to these issues by Congress, FISA was enacted in 1978 to prescribe procedures for conducting electronic surveillance and later physical searches within the United States for foreign intelligence purposes. A special and secret new court was created. Many of you know about it now, the FISC, Foreign Intelligence Surveillance Court. And that court could grant requests for surveillance if there was probable cause to believe that the target was a foreign power or agent of a foreign power. That's the predicate standard. Probable cause to believe that the target is a foreign power or agent of a foreign power. And further, if the government certified that, quote, the purpose of seeking the order was to obtain foreign intelligence. Rules governing law enforcement surveillance, as most of you know, are found instead in the Federal Rules of Criminal Procedure and in a statute usually referred to as Title III of a 1968 Act. And those rules, of course, require probable cause that a serious crime has been or is being committed and that particular communications concerning that offense will be obtained through the electronic surveillance before a warrant will issue. So there are 2 probable cause standards, 2 sets of requirements, and they're very different in their content. On the one hand, law enforcement and intelligence investigations often overlap. We know that now, particularly in recent years, because Congress has criminalized so many terrorist activities. Both rely on the same techniques, by and large, to collect. The information obtained forms the basis of evidence to support convictions and to learn about terrorism. Law enforcement information is often shared with agencies, other law enforcement agencies, with grand juries, and with courts. Intelligence, however, is in some ways a very different product and a process. It's conducted in secret. It's often open-ended in nature, longer term, sometimes simply conducted to keep tabs on groups or organizations. Foreign intelligence information may be hard for someone outside the intelligence community to evaluate, as they become what have sometimes been referred to as pieces of a mosaic. The law enforcement intelligence distinctions are not neat and clean by any stretch, and the roles overlap often in very productive ways. Good police work turns up intelligence and vice versa. but they differ in some fundamental ways too. Intelligence looks, by and large, to prevent future acts, law enforcement to prosecute completed or inchoate acts. The rules, the legal rules that apply to the two types of investigations are markedly different. Because the Fourth Amendment protects the people against unreasonable searches and seizures, the backdrop for both sets of rules is a core protection for individual privacy. When the privacy stakes are higher, when criminal processes and incarceration may follow, the rules are most protective of the individual and require the government to meet exacting standards before carrying out intrusive investigations. When the aim is to collect foreign intelligence, the secret and less protective rules of FISA may be employed. The looser or less burdensome FISA rules are justified because of the danger of international terrorism and because the privacy intrusions are limited to the collection of intelligence for foreign intelligence purposes. The divisions in the intelligence community that were formalized with the creation of the CIA in 1947 were quite purposeful. In part, the FBI and not the CIA was responsible for domestic security investigations because there was no enthusiasm in a post-World War II environment for a secret Gestapo-like agency. The FBI was always the crime fighter, but both agencies collected intelligence. At the same time, intelligence analysts knew the value of having two agencies partially in competition over the same turf. Rivals produce an array of intelligence, and the analyst sifts to find what is of worth. Following the Keith decision and the enactment of FISA, lower courts, the Department of Justice, and this FISC, the Foreign Intelligence Surveillance Court, administered these two systems of law enforcement and foreign intelligence by fashioning a pragmatic standard for determining when FISA could be employed by investigators instead of the more demanding law enforcement procedures. In essence, the courts and the government agreed if the primary purpose of the surveillance request was to gather foreign intelligence, then FISA could be used. Once an investigation became or was initiated as primarily a law enforcement investigation, the Federal Rules of Criminal Procedure and Title III would take over. There was thus a wall between the investigations to protect the privacy rights of those who were investigated for foreign intelligence purposes and to avoid tainting criminal prosecutions with evidence obtained through procedures that did not meet law enforcement Fourth Amendment standards. It was never the case that FISA or the purpose standard from the original legislation forbade the sharing of information between law enforcement and intelligence investigators. The only legal consideration was the one mentioned just a moment ago. At the application stage, was the application to the court, the special court, under FISA, primarily in pursuit of foreign intelligence? If so, that there were also law enforcement reasons to investigate the target would not preclude issuance of a FISA order. During the 1990s, the Justice Department developed procedures to enforce the integrity of the two systems. Although the procedures as written permitted information sharing between law enforcement and intelligence, between the criminal division and the National Security and Counterterrorism divisions at FBI, the procedures as implemented by OIPR in Justice were done so that they effectively walled off the criminal division of FBI from the other two. In essence, the rules as written by DOJ permitted reporting of reasonable indication of significant crimes from intelligence to the criminal division, consulting between the two divisions' personnel, providing guidance to FBI aimed at preserving the option of criminal prosecution, with the only admonition being that the criminal division was not allowed, quote, to direct or control the FISA investigation toward law enforcement objectives. This was a key standard. It was approved by the FISC, the court, and actually institutionalized there as a rule of procedure in the court. OIPR implemented the rules to erect a higher wall. In effect, the rules were implemented to prevent intelligence officials from even communicating with criminal division regarding ongoing foreign intelligence investigations. This cut intelligence investigators off from criminal agents and from AUSAs, some of the best resources for getting terrorism information in the 1990s. FISA didn't mandate this wall, and the statute did not bar prosecutors or agents from turning over intelligence to intelligence agents, nor did it stop the intelligence agents from sharing with the criminal agents evidence of crime they found in their collection work. Such evidence could be, and often was, used in a criminal prosecution consistent with the primary purpose test. By the time of 9/11, these procedures as implemented were getting in the way of sharing information between the criminal and national security divisions. In response to 9/11, Congress passed the Patriot Act, including that simple amendment in Section 218, 2 words, that require that foreign intelligence collection be a significant purpose. See the difference? 1978, it was the purpose. As interpreted by the courts, it was primary purpose. Now it's a significant purpose. Congress also added in Section 504 another information sharing provision that permits officials who conduct electronic surveillance to acquire foreign intelligence, quote, to consult with law enforcement officers to coordinate efforts to protect against international terrorism, and that coordination should not preclude certification of a significant purpose of the surveillance request to gather intelligence. DOJ quickly issued procedures to implement the statutory change and petitioned the FISC that it vacate its wall procedures to the extent inconsistent with the new rules. In May 2002, all 10 judges then on the FISC agreed in an en banc opinion that one portion of the new rules eviscerated the wall and could not stand consistent with FISA. They struck only 2 paragraphs of an extensive set of new procedures, but they were the 2 that I was just referring to a moment ago, and the court reinserted its earlier admonition that the criminal prosecutors not be able to direct or control the use of FISA procedures. By November of 2002, in the first ever convening of a FISA Court of Review, a 3-judge panel resulted in reversal of the en banc FISC, and the FISCer, as we now know it by that new acronym, held that the Justice Department rules followed the plain meaning of Section 218 and Section 504, the 2 Patriot Act provisions, and that such changes were well within congressional authority in the 4th Amendment. I think that the FISCer misread FISA and the Constitution, but minimized the harm that their analysis caused by resting their decision on a fallback position of the government that leaves some room for compromise and reform. In the end, the rhetoric about the issue and the opinion obscured 2 realities. First, that there wasn't much difference, really, between what the FISC ordered, the lower court, and what DOJ wanted. And second, that FISA remains, at its core, a mechanism for the collection of foreign intelligence. The problems of information sharing are far more about the culture and tradition and bureaucracy than they are about law, Patriot Act or otherwise. The FISCer holding was that the criminal division can direct and control FISA applications consistent with the statute and with the 4th Amendment. The court, however, acknowledged that DOJ can't do that if the sole reason for getting a FISA is to prosecute. So the court recognized there a 4th Amendment limit to what Congress could do. On the one hand, the argument about 218 may be much ado about very little. 218 may have been legally unnecessary. DOJ could have changed its internal guidelines, the one that had been implemented in an overly zealous way by OIPR. They could have changed those guidelines to make sure that OIPR didn't keep agents from sharing information. The argument goes then that the sunset here this year would not be a significant issue. If 218 lapses, the DOJ, FISA, FISC practice can and should remain unchanged. Information sharing should go forward. On the other hand, maybe 218 did not and could not eliminate the portion of the wall that is required by the United States Constitution. The sub-constitutional impediments to information sharing may or may not have been mandated by FISA and arguably could be repaired by new Justice Department rules. To the extent, however, that 218 permitted surveillance undertaken solely for law enforcement purposes on less than criminal probable cause, it may violate the Fourth Amendment. Here are a couple of bottom line points that I'll make in the very end. 218 and the Fisker decision dismantled the wall but did not and could not permit a FISA substitute for Title III when the only purpose for surveillance is to obtain evidence for prosecution. If 218 is reenacted, the Justice Department should revise its guidelines to clarify the above and to make certain that a significant purpose of a surveillance request is to collect foreign intelligence. If 218 is reenacted, it may nonetheless be unconstitutional if construed to permit surveillance directed solely at prosecution that doesn't meet Title III probable cause. If 218 sunsets, the resulting language, assuming there was no other legislative alternative, would fall back to the original language, which required the purpose be to collect intelligence, which would be a more difficult predicament, I think, for Justice Department in terms of the rules that would have to be made. Finally, Section 504, which is not subject to the sunset, that would buttress the conclusion that information sharing remains lawful, notwithstanding the purpose requirement. If the certification requirement of 504 is used to support a law enforcement surveillance request to the FISC, the old purpose language, the original one, would have to be harmonized with the remaining Section 504, and if you read the sunset of 218 for what appears to be its obvious purpose, failure to extend 218 or its equivalent would send a clear signal that the dismantling of the entire wall was not worthy of a longer lease. So 504 would have to be read only to permit information sharing so long as the purpose of the application to the FISC was to collect foreign intelligence. Thank you.
Let me start by saying thanks to Chris and to Scott and to Judge Everett for including me in this event. I'm very honored to be here, and also to thank the Wickershams for sponsoring this important event. I'm going to break ranks a little bit with my colleagues on the panel by talking about something that's only tangentially related to the Patriot Act, but as we'll see, it does have a connection. Let me start this way. In the late 1990s, Carol Steiker wrote a pair of extremely influential articles that described an emerging trend in our society that was then starting to get a lot of attention. This is the trend towards away from a traditional punitive state with a focus on ex post punishment for harmful acts or attempted harmful acts, and towards an emerging preventive state, as she called it. It's a parallel set of mechanisms that are oriented more towards preventing harm before it occurred. One of the many manifestations of the preventive state was seen in a set of creative new measures in a lot of different areas that were designed to incapacitate potentially dangerous persons. The big example that a lot of people were focusing on at the time being sexual predator incarceration, separate from criminal prosecution. Now, the curious thing about this trend at the time to me was that it wasn't really reflected in the substantive criminal law relating to terrorism. You didn't really see this in our counterterrorism laws at the time. Now, that's changed since 9/11, of course. We now have a terrorism prevention paradigm that suffuses all of counterterrorism law on the domestic side. And in fact, what we now have is that counterterrorism law is not only part of the broader trend towards the preventive state, it actually helps push the envelope on that trend. Now, we perceive this change most easily, I think, in the Patriot Act itself for the reasons that Chris noted in his introduction. He talked about the investigative and surveillance power enhancements, and those are really very visible and obviously quite controversial manifestations of the new drive towards prevention. But the question that interested me a while back was, what about the substantive criminal law side? Given how sweeping the changes introduced by 9/11 have been and the broad impact of the emphasis on prevention, hasn't substantive criminal law also been changed? And as I looked into this more and more, I came to the decision that yes, there has been a change, a very subtle one in some ways, but there has been a change. So my goal today is to convince you of what this change is and to describe the way that prosecutors have been able to evolve, in effect, a capacity to incapacitate potentially dangerous persons, in this case, possible terrorists, within domestic criminal law. And this is going to have something, well, a great deal to do with the law known as the Material Support Statute, 18 U.S. Code, Section 2339B. Now, the Patriot Act connection is this. The Patriot Act doesn't create the material support law. It amends it in a small but important way, but the law predates the Patriot Act. But nonetheless, as the material support law has turned out to be so central to the domestic criminal law enforcement front of the war on terrorism, debates about the material support law have now become intertwined with Patriot Act review, and it's going to be part and parcel of the congressional review that's going to take place in the upcoming months. So you're going to be hearing a lot about this. All right, so what am I planning to do today? I'm going to start by trying to describe how this change I'm referring to, how did it come about? Then I'm going to talk about there are many controversies associated with it. I'll talk about just a few because of the time constraints, and I'll try to suggest some possible reforms, both from a national security perspective and from a civil liberties perspective. Okay, now I recognize we're in the post-lunch lull. I teach a class at 1 o'clock normally, and I know this look. So what I'm going to do, of course, I get the same look in my 9 a.m. class too, so maybe it's me. What I'm going to do is I'm going to tell a story. It's a rainy day outside. The shades are drawn. I'm going to tell us a story, and I'm hoping that it will not put you to sleep, but it'll be vivid enough to keep you awake. And I think it also is a good story to illustrate why the change is taking place and why it really presents a tough issue, why it shows there was a real dilemma that needed to be resolved. And this story starts with a man named Kamal Derwish. Now, that probably rings a bell for you. Some of you will know right away who I'm talking about. He's most well known because he was one of the individuals, one of the suspected al-Qaeda members who died when we used a Hellfire missile fired from a Predator in Yemen to strike a car carrying these guys. That's what made the headlines. But he's got an interesting past before that. Derwish was born in New York, so he's an American citizen. Grew up in Saudi Arabia. From there, he goes on to train at the camps in Afghanistan. From there, he goes on to fight in Bosnia. Goes back to Saudi Arabia, spends some time in jail there. Upon his release, comes to the United States, and he settles down in Lackawanna, New York, a name that also probably will be familiar to most of you, and that's the story I'm leading into. In Lackawanna, New York, you have a large Yemen-American Muslim community, and Derwish begins engaging with that community essentially in recruiting efforts. He spends a lot of time with the young men at the mosque, talking about the virtues, indeed the obligations of armed jihad, and he's very convincing. And these young men, some of them anyways, found it quite persuasive. By the early spring of 2001, a core group had formed around him and another al-Qaeda-related individual that I'm not going to talk about. And these men eventually decided they were willing to do something about it instead of just nodding along during these exhortations. So 7 of these young American men decided that they were going to go to Afghanistan. They didn't tell that to their friends and family. They said they were going to Pakistan to do some studying. But once in Pakistan, they crossed over to Afghanistan, spent some time at an al-Qaeda safe house, and then eventually ended up at the now well-known Al-Farouk training facility, which is where a lot of the more famous individuals we've come to know and love over the past couple of years spent their time in training. And they entered into what we now know of as the basic training course at Al-Farouk. A couple of them even had the occasion to sit down face-to-face with bin Laden and have discussions with them. Bin Laden, of course, being well aware that there were Americans in the camp, and that was of great interest to him. The short version is that one of the men never came back. We think he's in Yemen now. We don't really know. At least I don't really know. 6 of them did come back, and they came home to Lackawanna, and when they did, they resumed their lives very much as if absolutely nothing had happened, as if they'd just gone to South Padre Island for spring break. I mean, nothing was different. And we know this because the FBI was watching. By this time, the FBI had been tipped about the men. They were watching to some degree. I don't know how tight the surveillance was then. This is all pre-9/11. Of course, after 9/11, the surveillance tightens up considerably. And in fact, after 9/11, the question became, were these guys an al-Qaeda sleeper cell? Is this wave 2? Is this another cell waiting perhaps for the anniversary of 9/11 to come around so they can strike again? So they're getting close surveillance. And in fact, we know now that the FBI director was getting twice daily briefings on the status of the surveillance. We know that the president himself was keenly interested in the case, getting periodic, if not daily, briefings on the case. But the problem was that these guys were living a very ordinary life. No law-breaking whatsoever, no indication of what, aside from what they had just gone and done in terms of training and associating with al-Qaeda, no indication that they were now up to something else. Some observers said they probably are just misguided adventurers who got in over their head prior to 9/11. Others took the view that this just simply exhibited good operational discipline. This is like someone referred to yesterday. They're not running, so they're disciplined. You know, the ones that run are just the undisciplined operatives. So, you know, what do? You don't really know in this situation. So the status quo was to maintain surveillance for a while, but then the anniversary of 9/11 starts getting near. The chatter picks up about a possible second strike, and the natural candidates, it's these guys. This is who people think the most likely candidates are. Now, the FBI, according to reports I've read, took to the view that surveillance would suffice to keep an eye on these people, and that was the better course. The CIA, according to these reports, was more inclined to incapacitate the men as the most likely sleeper cell within the United States. And eventually that perspective prevailed, most likely because of an email that one of the Lackawanna Six sent while traveling abroad. And I'll just quote from it so you have a sense of why the decision was made to err on the side of safety here rather than, well, I don't know if it's erring on the side of safety, but erring on the side of taking them into custody now. The email read as follows: I would like to remind you of obeying God and keeping him in your heart because the next meal will be very huge. No one will be able to withstand it except those with faith. There are people here who had visions, and their visions were explained that this thing will be very strong. No one will be able to bear it. Now, comically, his friend who received this email wrote back, "Big meal, what are you talking about? I don't know. I don't get it." Nonetheless, this was sufficiently disturbing in light of the increasing cost of surveillance and the growing chatter about a second strike. The decision was made at the highest levels to take these guys off the streets now rather than continue surveillance. The question is, how do you do it? According to reports, the Secretary of Defense, supported by the Vice President, urged President Bush to designate the men to be enemy combatants a la Jose Padilla, use the military detention model on these men to take them off the streets. To his credit, the Attorney General said, no, I think we should use the criminal justice system if we're going to do this. And he prevailed in that argument. And the interesting question is, how did he make a convincing case that DOJ had the capacity to take these men down? I just told you that they'd been watched for a year and they didn't seem to be up to anything. All we knew was that they'd associated with Al-Qaeda, or putting the worst spin on it, they'd even joined Al-Qaeda, and that they'd been trained. They'd received military training from that group. This doesn't give you grounds for a traditional inchoate crime charge, does it? They haven't attempted anything. They're not conspiring to accomplish any particular object, although there are obviously good grounds for concern here. No Al Capone-style pretextual prosecutions available because, as I said, they're living clean. They're not giving the government something substantial to use to incapacitate them on another ground. They might have been detained for a time on a material witness arrest warrant, but that's only a temporary fix. It wouldn't resolve the long-term question of incapacitation of potentially dangerous persons. So what happened? Well, they were prosecuted under the Material Support Statute, 18 U.S. Code, Section 2339B. Now, I need to tell you some things about the Material Support Statute so you can appreciate why this was different than how that statute previously had been thought to apply in a scenario like this. 2339B was enacted as part of the Anti-Terrorism and Effective Death Penalty Act of 1996, and it is best described, I think, as an embargo statute. We're all familiar with the statutory authority of the president to embargo foreign states, to impose a blanket limitation on trade or interactions with designated foreign states. This is the same thing for sub-state actors, terrorist organizations. And reflecting that embargo mindset, there is no mens rea requirement in the statute. There's no requirement of showing that the donor defendant intended to cause any particular harm. In fact, it's no defense to say that you intended nothing but great results to come from your donation of funds or equipment or services. And I should say the definition of material support is sweeping and broad. All that's required is that you know the identity of who you're donating to, and you at least be aware of their violent activities in a nutshell. Now, interestingly, the definition of material support includes the words training and personnel. You cannot provide training to a designated group. You cannot provide personnel to a designated group. Here's where the change comes in. These guys didn't provide training, they received training. They didn't provide personnel, they weren't recruiting for Al-Qaeda, they were themselves recruited. And yet those two qualities of what had happened with them does really clearly mark them out as potentially dangerous persons. And so what prosecutors did was simply to read this definition to include that scenario. Read the statute as if it includes the receipt of training as opposed to just the provision of training and the provision of yourself as personnel. And I submit that that was a substantial increase in the ability to use this statute for preventive purposes, because now what you can do is look at these potentially dangerous people, and those very qualities that make them dangerous are now criminal acts, the association with al-Qaeda and the receiving of training from them. Now, they argued that the indictment should be dismissed because that's not a reasonably foreseeable interpretation of the statute. That argument failed in the district court level, and they subsequently pled guilty. Let me just note real briefly, in case you're wondering, was this a one-off event? I don't think it is. I've done a comprehensive survey of charging decisions that federal prosecutors have made during the 3 years after 9/11 in terrorism-related cases. If you're interested in seeing the results, do a Google search for the terms terrorism prosecution statistics, and it'll pop up probably the first thing. You can look at the data yourself. The short of it is that it reveals that in 47 cases involving 130 individuals, 56 of those individuals were charged with violating the material support law. Almost none of them look like the Lackawanna case. Almost all of them look to varying degrees like an embargo-style case where the concern is cutting off support for the group, not taking down a potentially dangerous person. But in addition to the Lackawanna case, there are a couple of others that look to me, at least as an outsider, like potentially dangerous person prosecutions. The case of Mohammed Warsami in Minnesota, the case of Ayman Ferris in Ohio. Both of them, to me, reading the indictment, seem to have at least elements of the notion of providing yourself as personnel, making that a ground for prosecution. So there's the change I want to identify. Now let me just quickly note what some of the subsequent events were. That was a matter of interpreting how to apply the statute. Congress has ratified these interpretations since then. In the Intelligence Reform Act last year, it ratified both of those interpretations. It ratified the provision, the interpretation that you can't receive training, by actually passing an express ban on doing just that. It is now very clear you cannot go abroad to receive training from a designated foreign terrorist organization. And with respect to personnel, the Material Support Act was amended to be very clear that Congress's intent is to ban, including the provision of yourself, the provision of personnel to a terrorist group. Now, is any of this problematic? Now that the interpretive issues have been taken off the table, should we be concerned from a civil liberties perspective? Or does this not go far enough? Should we be concerned from a national security perspective? Yes and no as to each statute, or each of those two ideas. On the personnel front, the idea of making it a crime to provide yourself as personnel to a designated foreign terrorist organization, there's a significant civil liberties constitutional problem here because of the lack of a mens rea requirement in the material support law. The precedent that's relevant here is Scales versus the United States, 1961, construing a very analogous provision of the Smith Act dealing with subversive organizations. The short of it is that Congress then had clearly made it a crime to be a member of a subversive organization such as the Communist Party of the USA. Scales said, you can do that. Congress has that power. But you must require prosecutors to show the defendant's specific intent to further the illegal ends of the organization. That's the quid pro quo for criminalizing membership. So I would submit that to the extent that the material support law is now being used to accomplish effectively the same end, criminalizing members or personnel of al-Qaeda and other designated organizations, Congress either needs to go back to the well and for that particular circumstance, impose a mens rea requirement as Scales requires, or at least reviewing judges should read that into the statute, as the Supreme Court did in Scales itself. And I know time's running out, so let me just touch briefly on the training front. Here the problem, in my view, is not a civil liberties problem. In fact, it's the contrary. I think that the statute, this ban on receiving training, I don't think it's strong enough. And the reason why, it's actually a problem with the material support law itself. You see, both the new training ban and the original material support law, they work only if you've connected the defendant to a designated foreign terrorist organization, a group that is a coherent group that can be named, can be designated, and in fact already has been put through the formal process of being designated. That works great for the Hamases and the Hezbollahs of the world. As Jane Harmon told us at lunch today, and as I'm sure we're all familiar with, that's not such a good fit with the new generation of terrorism threats that we face. The decentralized networks we hear about, the like-minded individuals, the small ad hoc groupings that coalesce sporadically and in ways that would make it awfully hard to formally designate them, perhaps even to put a label on them that will mean anything from 1 month to the next. And what I'm suggesting is that the laws that we have in place right now, which are also keyed to the existence of a designatable organization, those laws have declining utility going forward. Every day as the threat becomes more decentralized, those laws become less useful. And one solution I'll just mention briefly is that we might want to look into, with respect to training, a provision that requires ex ante permission, an ex ante licensing scheme for people who want to go abroad to receive military-style training. That way you don't have to get into the designation process at all. There's so much more we could talk about, but I don't want to run on any further. So thanks for listening, and I look forward to your questions.
Well, thanks a lot. Is this microphone on? Oh, okay, good. I'm Tim Edgar with the ACLU, and I have to say that I feel that it's a great honor to be the last speaker here at this conference. I think it's been a fabulous conference, and I think we should all give just everyone involved with organizing it a round of applause, because I just... It's rare at a conference that I find two or three, potential expert witnesses I'm going to be recommending to members of Congress in the probably fairly near future, but I have today, this afternoon. I wanted to talk today a little bit about our work around the SAFE Act. That's the primary vehicle for reforming parts of the Patriot Act. It is an acronym, just like the Patriot Act was, so we can play at this game. It's the Security and Freedom Enhanced Act. We changed it from last year's Security and Freedom Insured Act because, of course, we can't insure security, which I think is the right thing to do. And it has a bipartisan coalition of strange bedfellows. And no matter how often we put together a coalition of strange bedfellows, people love to keep hearing about it. Former Congressman Bob Barr, author of the Defense of Marriage Act, himself married 3 times, a board member of the NRA and one of the impeachment managers for Bill Clinton, who actually lost his seat in Congress because in a primary race in Georgia, his opponent in a Republican primary convinced the electorate that Mr. Barr was too obsessed with Clinton, is one of our leading lights in defending civil liberties, and has agreed to become the chairman of a new organization, the Patriots to Restore Checks and Balances, which is composed of the ACLU and a growing number of conservative groups, including some of the largest and most influential membership-based conservative organizations, including the Free Congress Foundation, the American Conservative Union, the Gun Owners of America, and I can go on. So one thing I wanted to say is that the Patriot Act is a vast statute. The sections that we've just briefly touched on, Section 218, Section 805, which is the material support section, in fact are not fixed, are not amended by the SAFE Act. So, we believe that the agenda for looking at the issue of the Patriot Act and civil liberties is not going to be limited, in our view, at least under the ACLU's view, or shouldn't be only to those things that are in the SAFE Act, and shouldn't really be limited to the Patriot Act itself. But I do want to, for reasons of time, just focus mainly on the Patriot Act, or on the SAFE Act, sorry. So what is in the SAFE Act? It fixes about a half dozen provisions of the Patriot Act, some of which are subject to the Sunset Clause and some of which are not. The first thing it does is it deals with the issue of roving wiretaps. And these are wiretaps that will follow the target rather than the device. And they pose significant privacy concerns. The Fourth Amendment says that governs all surveillance and searches in this country, says that you must particularly describe the persons and places to be searched, the things to be seized, and the courts have agreed that that applies to wiretaps. In the criminal area, for several years before the Patriot Act passed, the government had this authority to use a wiretap that follows a person from phone to phone on a showing that they were trying to thwart electronic surveillance. And the Patriot Act extended this authority to FISA, extended it to the Foreign Intelligence Statute. The problem from our perspective is they extended the power without the safeguards. The two basic safeguards that are omitted from roving wiretaps under FISA, the first is, to me, it's either a drafting error or it's an extremely serious conspiracy. And I'm not sure which it is. I thought it was a drafting error because I'm not a conspiracy theorist. But if it was a drafting error, I don't understand why the Justice Department seems so intent on resisting correcting it. And this is that the statute says that you may have an order for surveillance that doesn't specify either the phone or the person. In our view, this isn't a roving wiretap at all, because you're not actually following a person and roving around. Instead, it's a John Doe roving wiretap, or what the framers of the Constitution would have called it would have been a general warrant, one of the things that we rebelled against the British to abolish. So our view is that we should fix that, and it should say that you have to specify either the phone or the person. And to be clear about this, we're not saying you would have to know the target or the person's true name. You might have an alias. You might, have to specify the identity some other way. But it to us seems reasonable that the government would have to either specify the phone or device or the person. The second problem is the ascertainment problem. One of the safeguards Congress insisted on in the criminal area was that if we're going to authorize this kind of roving surveillance that was controversial, that the government ascertain that the target is using that telephone. This is to avoid the following problem. I might be, imagine for a moment that I am a follower of bin Laden and under a FISA surveillance right now. As I walk into the door of this facility, does that make it open season on every phone in the entire center? We think that that shouldn't be, that that's not what roving wiretaps were supposed to do, and that there should be an ascertainment requirement so that my phone could be listened into, but not all of your phones. So that's our modest suggestion for roving wiretaps. The next area that it addresses is the sneak and peek warrants. I do find it somewhat amusing that we always talk about how the critics call them sneak and peek warrants and the Justice Department calls them delayed notification searches. That's relatively new. If you look at the manuals the Justice Department issued prior to 2001, there are sections on sneak and peek warrants. That's what they called them, so we call them that as well. What we do there is, do we abolish them? No. I think we do understand that as much as we think notice is an extremely important part of executing a physical search warrant, that there are very limited circumstances under which notice can be delayed, and our concern is to make sure that those circumstances stay limited and that the judges have a meaningful standard to look at. So we eliminate the catch-all, the so-called catch-all exception, and would require the government to show one of 4 specific harms to get a sneak and peek warrant. To get a delay in notice, they would have to show that immediate notification would cause the subject to flee from prosecution, would cause destruction or tampering with evidence, would endanger life or physical harm to an individual, or would it, would result in the intimidation of potential witnesses. So for our efforts here, we're sometimes accused of supporting the terrorist tip-off amendment. I can, again, assure you that I would think that if there was really a terrorist tip-off situation, the government could easily get a sneak and peek warrant under any of those 4 circumstances. The other thing that this amendment would do is provide a time limit for the delay, which was the law prior to the Patriot Act in at least 2, maybe 3 federal circuits, depending on how you count it. And that would be an initial period of 7 days, and then we've actually liberalized it a little bit in this year's version of the SAFE Act so that renewable periods can be as long as 21 days, and then those can be renewed. The idea here, again, is flexibility for the government, but with judicial review and oversight. The government says these are rare warrants, that they represent a small percentage of criminal search warrants. If that's the case, I don't really understand why this additional step of having some renew and some additional review would be so burdensome for them. The next area where really the bulk of the SAFE Act is directed is towards reforming these records searches. This is the library records provision. I never know whether to call it that and embrace it or to embrace the Patriot Act supporters' derision of that as the so-called library records provision. What I can tell you about that is that it's a provision that allows the government using FISA to obtain a court order from the FISA court to obtain any and all tangible things. There are two real reasons why it's the library records provision. One is that during the debate on the Patriot Act, the American Library Association made a modest request that library records be left out of all tangible things, which was denied. So it's not like somebody just dreamed up that somebody might want library records. I mean, it was a specific area that they wanted to preserve state privacy laws that require a higher burden to obtain library records that was denied. The other reason is that we have had in the past a program called the Library Awareness Program, in which FBI agents monitored what people were reading, and it was a program that was terminated for civil liberties reasons. So it's not something that's simply an imagined problem. From our perspective, obviously, we're concerned about that privacy. We're also concerned about the privacy of many other records. Some people often asked us, I often get asked by members of Congress or their staffs, well, if we solve that library problem, would that be okay with you? Well, I care about genetic information. I care about financial records. I care about lots of personal records. And I do think that there are some that deserve additional protection, library records being one, membership lists of political organizations being others for the First Amendment. But I view this as a broader issue. What this does is it corrects several problems in the statute. It would give the recipient a right to challenge explicitly, which they don't have now. It would require that there be a showing that the secrecy order is required, and it would give the person who's receiving it the right to challenge that secrecy order, which currently is automatic. It would provide a time limit for the secrecy order, which is currently forever, unlimited. And it would give notice to the target if this information is used in a subsequent proceeding, which is harmonizing it with many other provisions of FISA that provide that same level of notice. And then finally, what I think is probably the most important provision, although it may be the most difficult for us to get as well, is the limit of the type of record to specific and articulable facts that the record pertains to a foreign power or agent of a foreign power, which in the area of foreign intelligence investigations really is what I would argue the analogy to the requirement that there be relevance in a criminal investigation. Their argument is that relevance should be the test for both. My concern there is that foreign intelligence investigations are very far-ranging, and essentially what is relevant is defined by the government, whereas in a criminal investigation, the U.S. Federal Criminal Code defines that. You can't simply roving investigate anything you want. If there's no criminal activity, you can't do that. In the area of FISA, that traditional limit has been you're investigating the activities of foreign powers and agents of foreign powers, so I think that we need to preserve that limit as well. There's another type of records demand, which is like Section 215 with two changes. One is there's no court, so in that respect it's much worse than Section 215. These are called national security letters. In another way, it's not as bad in the sense that they're limited to certain discrete types of records. There's three of them, credit reports, financial records, and communications service provider records. These have been interpreted by the government very broadly so that, for example, Congress amended the statute actually recently to provide that financial records included not just traditional financial institutions, but casinos, pawnbroker shops, car dealerships, I mean, you name it. And because financial records are defined as anything that a financial institution holds about a customer, this means that the entire guest registry list of the, I was going to say the Montecito, but that's actually a fictional casino. But of any casino in Las Vegas is a financial record under the statute. And one reason that the Casino Association is part of our long and growing list of organizations from the right and left and in between that are concerned about it. There's a couple more provisions. There's a tricky issue involving internet surveillance. Basically, the government wants to apply What it says are analogous rules from the telephone analog world to the internet. We're concerned that the analogy isn't so apt. In the telephone world, you need an order based on probable cause to listen to a conversation, but to obtain the phone numbers dialed or received, you don't. All you need is a pen trap order. They want to basically apply that to the internet. We say, hold on. If you start looking at the routing information of my web browsing habits, there isn't anything left. You look up at the what's called the URL whenever you're on the internet, and you look at the string of information that's provided there. It shows you not only what website you visited, it shows you what page of the website, how long you looked at it, what search terms you entered into an online form. It's hard. You really would not get any more information if you had a video camera following you while you were doing that. Our view is that is content information. The government says they don't want to acquire content information, but has never been willing to sit down with us and come to some kind of agreement as to what content is. We don't actually solve that problem in the SAFE Act. It's a long list of problems that we don't actually solve. But what we do is we provide a slightly higher burden for pen trap surveillance. Basically, it's what we've called a beefed up relevance standard. So the standard is relevance now. We beef it up a little bit by saying you have to show specific facts, giving reason to believe that the information is relevant. This is designed to try to stop outright phishing expeditions and outright sort of trolling and data mining for information and focus it on specific investigations. Final two provisions, domestic terrorism definition. I have to say my civil liberties hackles got up a little bit when Professor Chesney talked about how he thought that we should strengthen the material support statute because sometimes, these organizations aren't even designated. Well, of course, we're concerned about guilt by association. We're concerned about the definitions of both domestic and international terrorism that are basically a three-part test. If you engage in activities dangerous to human life, if they appear to be intended to influence the government. So it's not if you actually intend, but if they appear to be intended and or a civilian population, and if you violate any state or federal criminal law. Our concern there is it's a far too broad brush definition. It doesn't take a great deal of imagination to think of a protest where someone throws a brick through a window, to think of civil disobedience tactics that may involve dangers to human life, climbing up a building endangers yourself, it may endanger others as well, lying down in front of traffic. You can go through the list, and under the plain language of the statute, and with people like Justice Scalia populating our federal courts, we're worried about what the plain language provides. That would be domestic or international terrorism. The essential argument I've heard from the other side is, trust us, we're the government. We're not going to do that. And so our view here is that one way to do that is tighten up the intent requirement a little bit. And this is the most important thing. Instead of providing that any criminal law, which could include trespass or other misdemeanors, that we would use the already existing list, and very long laundry list of some 40-odd federal crimes of terrorism that go through not only everything you could imagine, hijackings, bombings, and so forth, but computer crimes and a whole list, including some we may have a little trouble with. But we would essentially create a predicate list of terrorism crimes that, if they meet that definition, would be domestic or international terrorism. This is something that our friends on the right are probably more concerned about than any other single provision of the Patriot Act because of the activism of many right-wing organizations around the abortion issue in particular. That abortion protesters have taken a page from the playbook of civil rights activists and have used civil disobedience, have chained themselves to abortion clinics, and done other things that certainly, in their nightmare being President Hillary Clinton and Attorney General Obama going in there and trying to shut down their organizations, and it's a real fear. Then I did want to respond very briefly, my time's running out, to a couple of things about the frustration that we all feel, I think, sometimes around the Patriot Act. I do think that the debate And I would just say that we've learned today that in Washington, occasionally, debates involving complex and difficult issues that are emotional and that are featured in the halls of Congress or in presidential campaigns may involve overwrought rhetoric. Gambling is definitely going on here. I do plead somewhat guilty to whatever the ACLU has been. I think we have tried to be, and not always with complete success, as careful as we can without losing effectiveness in speaking to a lay audience about why these are important issues to be completely accurate. I completely endorse the headline of Senator Cornyn's op-ed in this Monday's Washington Times, "An Honest Debate, Please," in which he then proceeded to dishonestly claim that a lawsuit that we had filed and won at the district court level, striking down national security letters, had absolutely nothing to do with the Patriot Act, when, of course, because it struck down an entire statute rather than just the Patriot Act amendment. A kind of nonsensical argument. I agree entirely with that. I think that we can win an honest debate. I do think that there are a whole range of civil liberties issues outside the Patriot Act that people do confuse with the Patriot Act, I think for obvious reasons, which is that they are part of a package of the legal, sort of the legal approach to terrorism. But there are, I don't want that to obscure the fact that there are really serious problems with the way this massive statute written in the immediate aftermath of 9/11 was drafted. And I really do take a lot of heart, not only in our support that we've received from conservative organizations and conservative members, but the growing support we're receiving not only on the left and the right, but in the center from congresswomen like Jane Harman, who can be a tough cookie when it comes to these kinds of issues. And so I'm feeling better now, I think, than I did in a very long time about our potential success in fixing some of these problems. But I have no illusions that at the end of the year, we're going to have fixed all the civil liberties problems related to terrorism, or that we'll even have fixed all the civil liberties problems related to the Patriot Act. But I'm hopeful that we can move forward and get a positive change. And I would note that Senator Cornyn, after he spent a lot of time bashing us and calling us dishonest, endorsed some changes to the Patriot Act. So, I think that even our opponents, or people who feel that they're our opponents, are coming around to endorse at least some of the concerns that we've had about the Patriot Act. And now I'll sit down and let everyone answer some questions.
Thank you. Here, we do have the microphone circulating, Ann.
I'm curious as to whether anybody looks at this sort of divide between what's criminal and what's intelligence and all that. I mean, I used to understand this, or it used to be everybody's understanding, I think, that it had to do with international law and the way that states relate to each other. States cannot prosecute each other, but they use tools such as embargoes and wars. And as we extend these things and say that they're now applicable to private persons, I wonder what that has, what role that has in it. And as an example, some of the FISA changes, and this wasn't the Patriot Act you mentioned. It was something later, the Lone Wolf Act. I mean, it used to be if there was probable cause to believe that you're an agent of a foreign power. Well, then foreign power was redefined. So now foreign power can really be, a terrorist organization, or and then when they went to the Lone Wolf one, you didn't have to be an agent exactly. You could just be, I don't know, you had to be foreign still. But the rest of the definition, and I'm wondering how far does that go? Is there a line now that divides it?
Bill, you want to take that?
Well, for openers, yeah, the Lone Wolf Amendment was part of the Intel Reform Act that was signed by the President in December, and it's been proposed for a few years now, Senator Kyle and others, and didn't make it on 2 or 3 iterations of intelligence authorization and such, and nor in the Patriot Act. some say that the lone wolf proposal was a response to what's referred to as the Moussaoui problem, at missing who might be still alleged to be the 20th hijacker because he could not be reasonably connected to any foreign intelligence, international terrorism organization. Whether that's a reasonable analogy or not doesn't really matter, but the idea now is that you don't have to be affiliated with Al-Qaeda or Hamas or Hezbollah or anyone else if you are reasonably believed to be planning international terrorism. There's a real problem with the predicate, however, because it does permit secret FISA surveillance without any criminality in the stand.
Yeah, I think it's a very dangerous precedent, the lone wolf provision. I think that, you know, I had suggested to a Senate staffer who's quite conservative and often difficult to persuade that this lone wolf provision represented a camel's nose under the tent, and he said, no, Tim, it's worse than that. It's camels in the tent. And I think he was right. I mean, I think that we are trying to fight the idea, essentially. I mean, if there isn't a link to foreign governments or terrorist organizations, which is the first kind of step we've taken, which we at least can analogize to governments, say they are somehow like governments in some way, we're at war with them in some way. You know, if we get rid of that link, then intelligence is completely unbounded. And the techniques that can be used to gather information for intelligence purposes, you know, involve essentially all of the techniques of surveillance. And I think that this provision, you know, we were very concerned about. I think the good thing, I mean, it did take them 4 years to get it through, and it was because it was something that we had concerned. I think that this was an area where I agree with Mary that you don't necessarily say just because something would not have, in a narrow sense, prevented 9/11, it's not a good national security proposal. But in the lone wolf area, I do think that's a legitimate point to make, since it was proposed precisely to fix a perceived problem that turned out not to be a problem at all. And I mean, not only the 9/11 Commission, but earlier investigations had made quite clear that the Moussaoui problem had nothing to do with a problem that the law had.
I just want to say something real quick about Jen's question at sort of a broader level, setting aside the details of lone wolf and all that. And part of what's going on here, it reflects something that in public international law circles gets talked about under the heading of the post-Westphalian world, right? That we're waking up since 9/11 to the fact that we're no longer living in a world that can necessarily be defined by this, you know, the pool ball image of nation states as discrete entities only interacting with each other as states, and the reality that transnational and sub-state organizations, or perhaps foreign individuals, given the changes in technology, the inexorable increase in the ability of a given individual or group to access ever greater destructive powers, to travel more easily, to communicate more easily, even without the aid of a state, those sorts of changes are underlying drivers of the changes that these specific legal changes you're mentioning. So I think it's important to recognize that's part of the undercurrent here.
I would just add, I think I actually agree, despite what using the Lone Wolf Amendment as an example of the arguing on it wouldn't have prevented 9/11, I haven't heard a lot of good arguments for why they really needed it. And I do also have, it concerns me greatly that what you have now is a definition of an agent of a foreign government that is a person who is unaffiliated with anyone, and it's just a complete, you know, it's sort of turned the law around into an absurdity, and that troubles me.
Yeah, Professor Dicus.
I have a law question.
You don't have to get mad at us.
Some have regarded the Fisker decision 2.5 years ago as dispositive of the issues that the court addressed there. But of course, the Fisker is just one among many intermediate level federal courts. Now, I wonder if you have any ideas about how those same questions might play out in an appeal to a different federal court in the future in a criminal case testing the admissibility of evidence collected under a FISA order.
Well, you know, the ACLU filed an amicus brief, and in the Fisker case, it was an interesting exercise since we didn't have any, there were no procedures, and it was in fact, I think classified where the Fisker was and so forth. But we did end up managing to do that somehow, and argued that the significant purpose test was a violation of the Fourth Amendment, which we lost on. I think it's important to remember Fisker only binds the FISC, and you know, in a technical sense, so every other federal court can address this issue de novo as soon as a new FISA warrant under the new test is put in issue in any criminal proceeding. And the Fisker, of course, is appointed by Chief Justice Rehnquist and includes some of the most conservative judges in the country. So I do think that there's a good chance that at least one appeals court will strike down or in some way limit the significant purpose test as a violation of the Fourth Amendment, perhaps lone wolf as well, and that the issue will come back. It may take quite a while for that to happen, but I think there's a very good argument that it goes too far to say that when you are primarily investigating criminal activity, that you can use a statute that doesn't require probable cause of crime to invade somebody's constitutionally protected interest in their home or privacy of their conversations.
I agree with Tim essentially, in that the Keith case still is out there as a Supreme Court precedent that could permit another court, a lower or high court, to question on that standard. But while we're talking about the FISA, FISC, and Fisker, it might be also useful to point out that several of us were troubled by the procedure, first-time use of this court that had been theoretically around for 25 years, but had never been invoked because the government had never lost before. So these 3 judges had never seen a FISA case, never. And the 10 judges on the lower FISA court, of course, many of them had been steeped in FISA for years, and their judgment was repudiated, and it was done so without the basis of any adversarial proceeding whatsoever. There were no other parties except DOJ in the courtroom with the Fisker at that moment, and I think several people made reasonable proposals to add some, at least appearance of adversarial participation and, say, appointed counsel for the target who doesn't know who she is on appeal if there is a subsequent decision like that. Those changes did not make their way into any subsequent legislation, although there were some reporting requirements added to the Intel Reform Act this December that require the DOJ and the FISC now to give more detailed and more regular reporting about their activities.
Yes, sir.
My question's about an intersection between the domestic criminal and the military with domestic and international, and between the U.S. and foreign countries. The question I have is, does any of the USA Patriot structure prevent a foreign country, through its intelligence services, to surveil on Americans overseas or Americans in the United States as part of what they do, and share that information with either the U.S. side folks, FBI, or the foreign CIA as the collaboration in this post-Westphalian world where everybody's supposed to help? In particular, one of my concerns is somebody who is an American like that Lackawanna Yemeni that we would be surveilling on, who happen to live in Paris, could be looked at by the domestic French authorities, and with the French maybe want to share that with the CIA. The Americans haven't done anything, but it's the foreigners who've done the intelligence and assisted the Americans. And the last part of that is, do you get to these weird situations where you'd have the person in Lackawanna, and this is the domestic military side, is that they'll plead out, because the choice is plead out with us on the criminal side or go to Gitmo?
Well, yeah, Yeah, sure. First, I don't think there's anything in the Patriot Act that speaks to that scenario, though I've seen people raise that point previously, saying that what's to prevent us from doing the domestic spying for the British and the British from doing the domestic spying for us. I have no reason to believe that's going on. I've never seen anything, but it's an interesting thought experiment, and I don't know of anything in the Patriot Act or other law that would provide this. Although I think at a certain point, if, let's say, the FBI or DOJ was knowingly engaged in a quid pro quo like you're describing, I do think that that would require violations, if not to the letter, at least to the spirit of internal guidelines that do regulate this. But it may be that the letter of those guidelines don't actually cover that situation.
Well, I was just going to say, there are actually, I think, as I understand, fairly clear internal guidelines in the intelligence community that prevent that kind of quid pro quo, that kind of direct, at least, quid pro quo situation. I mean, those guidelines, so many of them are classified, and we don't always know when they've been changed. I think it's a significant danger. The practice, I think, in the past, and probably today, is to bar it by guideline. I don't think there's a statute that bars it. There is provisions, not in the Patriot Act, but there are information sharing provisions in the Patriot Act that were extended in the Homeland Security Act and then repassed for some strange technical reason in the intelligence bill, the exact same language, that allow a lot of this sharing to be made with foreign governments, including sharing of things like U.S. grand jury information, which is normally subject to Rule 6E. I think these are fairly disturbing provisions, actually, when you think about some of the types of foreign governments that we've been cooperating with. I saw it as the secret Syrian police get to spy on Americans provision, although it never became quite as radioactive as the Patriot Act. I guess my misleading and extremely inflammatory labeling didn't work in that one instance. But I am concerned. I am concerned that about. I think obviously we agree that there should be some level of cooperation internationally and intelligence sharing. The question, I think, is the limits and what kinds of governments are we doing it, and when are we doing it, and are we doing it for their purposes or ours, and all those issues. But those are also not directly Patriot Act, but very similar provisions, really.
Just and following up briefly on something else you mentioned, this idea that perhaps in the Lackawanna case, and of course also we hear this in the Lind case, that the threat of Gitmo was on the table. In fairness to the DOJ, I've heard many DOJ reps vociferously deny that any such threat was in the air. The people have pointed to plea agreement provisions, especially in the Lackawanna case, that explicitly call for not allowing a transfer to Gitmo at some point. And the story, as I understand it, is that was insisted upon by the defense attorney. So I don't know of any reason to believe that threat was ever made.
Well, maybe because the vice president suggested doing it.
Not to the defendants, not in any public way. We only know this thanks to the intrepid reporting of certain individuals.
Let's go all the way in the back.
I just wanted to offer a comment with respect to Professor Davis's question. And this, Charlie Williamson, United States Air Force. This is just my personal interpretation, but there is DoD Directive 5240.1-R, which is unclassified, and it prohibits U.S. military intelligence agencies from asking someone else to do something that we are prohibited from doing. So, and that is enforceable against military members under the UCMJ and enforceable against civilian members using a variety of civilian disciplinary tools. So I think that there are unclassified procedures, unclassified prohibitions, and ready enforcement mechanisms.
Yes, sir.
Thanks. Frank Davies, Knight Ridder Newspapers. I'd like to ask any on the panel where you would set the standard in the situation that Tim referred to in the infamous Section 215 for a record search, for a FISA order, when you're in a situation where the person under surveillance has a connection to some shadowy foreign entity. And maybe it's not clear, maybe it's not quite as clear as the training camp scenario, but it may not be as clear, certainly, as an agent of a foreign power, as Tim said. Where do you set the standard when government agent comes in and says, we believe this person has spent time with people we think are al-Qaeda or friends of al-Qaeda in Europe, or somewhere else. How is that evaluated, and where should the standard be set before you allow a very intrusive Section 215 search?
Hope they'll all endorse the SAFE Act.
Right. Well, I guess I don't know the SAVE Act as well as I should. I guess what you said is that it would require specific articulable facts of a relationship to a foreign power.
Well, right, that giving reason to believe, which is a much lower standard than probable cause, but more than nothing.
And that seems fair to me. I think the standard right now is really no standard. I mean,
Right.
it is the Justice Department has to say that we have an investigation, and it is entirely the Justice Department's determination of whether that is a reasonable investigation, and then it's like a subpoena that the judge just rubber stamps it. So I definitely think there should be more than that. I haven't thought specifically about this language, but it sounds pretty reasonable to me. I think clearly something more than the rubber stamp that's in there right now.
Well, would you join me in thanking our last panel for a very interesting session?
We'll get to use this.
It's that time when we've come to a close. I want to take this opportunity, one, to thank you. It's been wonderful participation in your questions and your comments. I also want to thank my colleague and literally co-sponsor of this entire conference, Chris Schroeder. He's been my right hand all throughout the many months of planning, and it's one of the many ventures we've done together, and I think it's a sign of the future. Lastly, there have been obviously a lot of logistic details that none of us as speakers or organizers handle. Those were done by folks outside, and I've got two of them in the back that I do want to acknowledge and ask that you thank. Doris Ann Kelly from our law school was responsible for putting all this thing together, and our principal contact with the Thomas Center, where all the meals were done and all the details of the Janine Auditorium, is Laura Small. So will you join me in thanking those two young ladies? On a final note, as you've noticed, we've had a camera throughout the proceedings as well as one in the meal presentations. What we will be doing is taking this digital tape, making a DVD or series of DVDs that will be, as quickly as we can do it, posted on the Duke Law website for researchers, folks who could not come, so that there will be hopefully a digital transcript of this entire conference from start to finish, so that you or your colleagues or those who Google us will be able to come in and listen to your concise and pertinent questions. We wish all of you safe travel home. The judge is reminding me, if you haven't already filled out the evaluation form, to allow us to hopefully do a better job next year. We do seek to improve. Many of you, Steve and others who have been here year after year, know that we do take these things seriously. And we are trying to come up with the best locale, the best topic. I'm not sure how we could do better as far as speakers. I think we got a world-class team this conference. But please tell us where we can do better, what you thought was good, what you thought was bad, and we do take those seriously. We hope all of you have safe travel, and we hope you'll come back to see us again next year.
So I was really worried about this.